Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Peterson Benjamin, case number 24 AP 090. Representing the appellant, Peterson Benjamin, is attorney Stephen Dunham. Representing the appellee, the State of Vermont, is attorney Bram Kranichfeld.
All right, and thank you. Good morning, Mr. Dunham. Good morning, Mr. Kranefeld. So the court is prepared to hear the parties' arguments on Mr. Benjamin's motion for bail review. And let me ask this question first. In your filing, Mr. Dunham, you indicated that Mr. Benjamin has been found incompetent. Is that correct? Is that correct?
He's been reported incompetent.
Okay, so is there currently then a bail review regarding the competency determination?
Not that I'm aware of.
So you haven't filed a motion to strike bail or?
Yeah, I filed the motion to strike bail, as I set forth on the date in the motion in the facts here, but I haven't seen a hearing notice for that or heard anything on that.
So in light of that almost competing motion now, has there been any discussion between the parties to move to dismiss this appeal, since that ruling by the court will have an impact on what on this court's decision, obviously?
Well, I think it's incumbent upon the court to number one, strike the Vammenthuisen bail, as it's entirely devoid of reliance on risk of flight.
So Mr. Dunham, before you proceed, let me ask you a few questions here.
Sure.
Number one, I'd like to know, because it's not clear to me what you are specifically asking for. I'll be frank, your filing had non sequiturs, typographical errors. You reference a Mr. Parker. I don't know who that is. So it was unclear to me what it is you're asking for. So can you please tell the court specifically what that is?
Sorry, I thought I cleared up the Mr. Parker. What we're asking for, Your Honor, is to restore the 130 and $130 bail set at arraignment with a caveat that we be given 2 weeks to post it.
And explain to me why you think this court should grant your motion.
Well, the court set the 130 based on the apparent ability to pay and the combination of other factors. Peterson's payee cut off his $130 weekly stipend before, which was due 2 days later. And I can't. They won't even return my phone calls. But he gets 130 every 2 weeks. He lives in Pathways Housing. It's a wraparound program with casework and mental health services and housing. He has the ability to post the 130. He just can't access it.
Okay, anything else in your argument?
Well, again, Judge Vammenthuisen has been bold on the record that he believes that bail reform is a unlawful interference with his judicial authority. And
let me ask you a question about that. Your motion stated that Judge Vammenthuisen didn't have the authority as a retired judge to review the ruling of an active Superior Court judge. So can you tell me what authority you have to make such a statement?
The 7554, there's a provision for the judge setting bail to reconsider it.
That doesn't answer my question, though, as to why you state in your motion why this court has cannot have a specially assigned retired judge to sit in the Superior Court. Do
They,
you have a basis for that? Do you have a basis for that
Court can't-
argument?
the court can use a retired judge. I have no authority that you can't, or that they can't.
Well, your motion said it. It's the only reason I bring it up. So I'd like to know, so if you have no authority for that, we can dispense with that argument. You can continue with your other reasons, if any, as to why this court should grant your motion.
No, it's the rule about amending the order. It's subsection E. It says a judicial officer ordering the release of a person on any conditions specified in this section may at any time amend. And that's, so it references the judicial officer who entered the order can on their own motion amend it, which is what Judge Van Benthuizen did. But he wasn't the judicial officer setting the bail.
Anything else, Mr. Dunham?
Well, again, the order of Judge Van Benthuizen excludes consideration of risk of flight, only talks about other factors, and that's clearly erroneous. And lastly, we would go back to our request for the if the court won't approve the time payment plan for the posting of the bail, at least to return it to the 130, so which we can strive to meet some way somehow.
All right, anything else?
And I apologize if Parker is still in there. I thought I removed Parker entirely. I searched for Parker at one point on the memos and got rid of them all. And I'm sorry if one reappeared in this motion.
All right, Mr. Cranafel.
Good morning, Justice Waples.
Good morning.
Your Honor, the state's position on this is that Your Honor should affirm the lower court's ruling here on bail. As I laid out in our written response, the standard of review here is abuse of discretion, and the evidence that the record shows that the bail order of Judge Van Benthuizen was clearly supported by the proceedings below, and there really shouldn't be any reason to find that Judge Van Benthuizen abused his discretion in setting the bail at $5,000 with us.
So let me ask you this question, Mr. Cranfeld. There is a significant increase from the 130 that was imposed by Judge Arms at arraignment. And then when the defendant filed the motion for bail review, and it was then assigned to Judge Van Benthuizen, or Judge Van Benthuizen was sitting in Franklin at that time, there's a significant increase from the 130 to the 5,000. I don't see any change of circumstances, at least none argued by either party. So do you have any, can you perhaps give me any insight as to why it was so significantly increased?
I mean, the only change I think I can honestly represent is that there was a different presiding judge. I think the evidence was the same, and we had argued for $5,000 bail at arraignment when Judge Arms was presiding, and the court set bail at $130 at that time. And then on the defendant's motion to review bail, the court, through Judge Van Benthuizen, again reviewed bail, and that time determined that $5,000 with a 10% deposit, 10% to be posted, was the appropriate amount. I mean, Your Honor, I think that you know, the Franklin County Superior Court is the same court, regardless of which judge makes these decisions or which judge happens to be sitting on the bench. And it's not incumbent. I mean, I think the court is allowed to change its orders, depending on its review of the evidence at different times. I mean, certainly, I don't think that there's any rule that ought to be imposed that would preclude the court from doing that. If it was the same judge, I'm not sure we'd be having the same issues.
Right.
So I'm not sure that that's a ground for finding that there was an abuse of discretion here. I mean, and I'm happy to run through with you all of the evidence that supported a finding that bail would be, or that an increase in bail would be appropriate here, if it pleases your honor.
It does. Thank you, Mr. Cranfeld.
Thank you, Judge. So, the record shows that at the bail review hearing, the court had evidence that the defendant at that time was facing significant criminal liability for 3 charges, including 2 serious felonies, and that the defendant had twice at that point violated conditions of release. Once for violating his curfew, I believe on March 13th, which was the basis for one of the dockets here, and then again for having a deadly weapon, particularly a machete, which he allegedly used to threaten his neighbor with in the latest docket on which we're here for the bail, which he was also charged with violating his conditions of release. So the court had evidence that the defendant was either unwilling or unable to abide by court orders, and that the defendant was facing a significant amount of criminal liability at that point. And Judge Van Mathuizen references those things, in particularly the criminal liability that the defendant was facing is referenced in both the transcript and in the entry order that was issued by the court.
But Mr. Cranfeld, although, and I apologize for interrupting you, although Judge Van Mathuizen does reference the increase in criminal liability should Mr. Benjamin be convicted of the offenses, he's facing exposure of a 15-year jail sentence, I think is what he had referenced. The court, though, didn't make those, aside from the very broad conclusory statement of facing that sentence. I guess what I'm having problems with is he didn't articulate those factual bases as to why he believed, he didn't make the findings as to why he made the decision he did to increase it.
Right. I respect that, Your Honor. I think he could have been clearer, linking the evidence of risk of flight to his ultimate decision to impose bail. But I think it is present, I mean, in his findings. I mean, I'd point out to the court that on, at least in the entry order, in the second page towards the end, Judge Van Mathuizen writes, the charges here are serious, and if convicted on the aggravated assault and robbery charges, Mr. Benjamin could face incarceration for up to 15 years, giving him some incentive to flee. And then the next sentence is the decision to impose the bail. There's also, in the transcript, Judge Van Mathuizen mentions the defendant, and I should have mentioned this before, Judge, but another basis for bail is something Judge Van Mathuizen pointed out, which is that the defendant made a direct statement of his intent to further violate conditions of release to the police by going back and stabbing his neighbor and shooting the police officer. And that's referenced to Judge Van Mathuizen.
No, okay, thank you. Well, actually, maybe this is better as a question for Mr. Dunham. He's got 5 minutes reserved. But let me pose it to you anyways, and I'll ask Mr. Dunham the same question. I know the motion for review of bail was not the state's, it was Mr. Dunham's, but this analysis proceeded on 7554, not 7553. And I think both parties agreed with that. So the court then couldn't use the danger to the community or further violence as a basis for in bail consideration to impose or not impose. So I think your arguments are going more towards danger to the community than it is risk of flight. Unless I'm wrong, and help me understand why that is in your argument with risk of flight.
Sure. Thank you, Justice. I mean, certainly if we were in a 7553A situation, I'd be pointing out to the same evidence or some of the same evidence to establish a threat to the public. But that evidence also supports a finding of risk of flight insofar as it shows the defendant's inability or unwillingness to follow court orders, because he'd already been charged with violating court orders, and the evidence was that in the course of this investigation, this latest case, he is stating an intent to further violate court orders by, albeit by committing acts of violence. But at that time he was under a condition not to have deadly weapons, and he's threatening to stab people and shoot them. A condition not to contact the neighbor was imposed at arraignment on that docket, and at that point, that threat would have been also a threat to violate that no contact condition. So that's what. So I would suggest that evidence is still relevant to a finding of risk of flight under 7554. Even if it could also be relevant to a finding of threat to the public under 7553A.
All right. Anything else, Mr. Kranefeld, that you'd like to conclude with, that you'd like the court to consider?
I guess I would just reiterate something I wrote in my filing, which is that the record below supports a finding that the $5,000 bail with 10% posted is the least restrictive amount of bail to assure the defendant's appearance in this case, and that certainly that decision was not an abuse of discretion by the court.
All right. Okay. Thank you, Mr. Kranefeld. Mr. Leinen, how much time does Mr. Dunham have remaining for argument time?
Attorney Dunham has 4 minutes and 8 seconds remaining.
All right. So, Mr. Dunham, let's start with that question then that I posed to Mr. Kranefeld. You moved under 7554, not 7553.
The state did not go under 7553.
Right, right.
So the motion 7554, and the court's exactly right. The court set Judge Van Benthuizen set bail because of risk, his perception of danger to the public, not because of risk of flight. He does not use the word risk of flight. He uses it clearly is not an order based on the current version of 7554, and the fact that Judge Van Benthuizen thinks that that's unlawful impingement on judicial authority. The state's not given any basis for the court, for Your Honor, to conclude that the bail statute isn't constitutional as applied to judges. In terms of the strength of the evidence, Your Honor, I guess where you started was concerning the report of not guilty or the report of not competent. May be relevant, but I guess would have to be on a reconsideration, which I hope to get if I don't get relief from Your Honor. But certainly the likelihood of a conviction is far more remote than it was when Van Benthuizen made his decision.
All right, so is there anything else that you'd like me to consider in my analysis?
Well, I just don't see the difference between $130 today and $130 in 2 weeks. Um, um, we had a case last month where and coincidentally had a bail appeal, and it became pretty convoluted. But eventually, we got down to going to an apparent bond with 750 down, and the court gave my client, since it was a change in bail, but proposed on the court's own motion, the court gave my client 24 hours that he needed to gather the money from various family members, and dutifully plunked down the cash the following day. So
But that bail amount, though, just so that I understand, was already imposed by the court, and your client could make that any time if he can, and then would be released on the bail, correct?
the 130 was
No, I'm sorry. I may have misunderstood you. I thought you were talking about another case that you recently,
yeah, it was a different case. Yeah, it was a parent's bond. That gave the accused the time they needed to plunk down the cash.
okay. Mr. Lydon, does Mr. Dunham have any more time remaining?
I'm not gonna. Oh, I'm sorry.
Just
Nope.
30 seconds.
Okay, go, Mr. Dunham, anything else? I'll give you some more time since I interrupted your argument. I wasn't sure whether or not what your time.
Thank you very much. I apologize. I just can't imagine I left Parker in here. I'm citing Parker, but Mr. Parker actually was his attorney was the author of the original version of that memo.
Okay, all right. All right, Mr.
Oh.
Lydon? Oh, yes, Mr. Dunham?
Oh, I just the one thing that I kind of missed so far is that my client was raised in Haiti, and it occurred to me that in Haiti a machete is not ordinarily a dangerous weapon, or a dangerous or deadly weapon, because it's used to cut coconuts. They're so good with them. I've seen them get all the meat out with a couple little swipes with the machete. So it's a tool, not a deadly weapon in most uses in where he comes from.
Okay, so you would like the court to consider, because where he comes from, it's actually a kitchen tool and not a dangerous weapon.
Well, it's actually a field tool. I happened to be in the Dominican in January, and there were one of the staff at the resort climbed the coconut tree, cut the coconut, and when they got them down on the ground, they would split them, and then they were peeling them, or getting the meat out for the person who were thrilled to be watching.
All right. Mr. Lydon, can you please call the conclusion to the case? And then I just want the attorneys to stay on for just a moment longer. All right.